All right, good afternoon. My name is Abhidan Cover. Among other things, I serve as the director of the Institute for Global Security Law and Policy. And I'd like to welcome you to today's talk. Today's talk, Immigration, the Forgotten Environmental Issue, serves as a useful pivot point and bridge of sorts within our society and our law school's own discussion and debate over immigration and environmental matters. In the past weeks, we have held here at the law school debates over executive power in the immigration context and held a moving and informative discussion led by immigration advocates on the experiences of undocumented people, including a Mauritanian family here in Ohio. Next month, November 11th at noon, we will hear from renowned expert on refugee law and Michigan University law professor James Hathaway. And this Friday, the law school will host an all-day conference on the EPA's 50th anniversary, which is actually next year, featuring as a keynote EPA Administrator Andrew Wheeler. The conference will address EPA's history, its successes, its failures, and its future outlook. Our law school prides itself on hosting and debating important legal and policy matters of the day. This often means that we operate in a space that is hotly contested, that includes sincere and divergent views that may at times offend some. But to shy away from these debates would shirk our responsibility both as an academic institution and as members of the polity. None of us is benefited if we each reside in our own filter bubbles. None of this is to say that we cannot disagree with one another or a speaker. We should, however, open our ears to listen and hear from one another. But to question and criticize is also an obligation at our law school and in our society. We should only act with civility and respect. For today's talk, our guest, Julie Axelrod, will speak for about 25 minutes. Our own Professor Jonathan Adler, the director of our new Coleman P. Burke Center for Environmental Law and widely published scholar in the fields of environmental and administrative law, will then offer a few comments, and then we will open it up to the audience for some Q&A. A bit about our speaker. Julie Axelrod serves as the Director of Litigation for the Center for Immigration Studies. She manages the center's environmental and FOIA litigation dedicated to, quote, uncovering the impact of immigration on American society, particularly on the environment. A native Californian, quote, her biography provides, she has always had an acute sense of the dangers of out-of-control immigration, end quote. Ms. Axelrod is currently litigating the nation's first challenge to the DHS procedures under the National Environmental Policy Act for failing to consider the environmental impact of its immigration programs, and that case is in the Southern District of California. Ms. Axelrod also served previously as senior counsel for the Immigration Reform Law Institute, the legal arm of the Federation for American Immigration Reform. She also served as a staff attorney at Judicial Watch and at the law firm of Mayer Brown. She clerked for the Honorable James Lawrence King in the Southern District of Florida and graduated magna cum laude from Dartmouth and received her Juris Doctor from the UCLA School of Law. Please join me in welcoming Julie Axelrod.
Thank you. So, as he said, I work for the Center for Immigration Studies, and our primary mission is to look at the costs of immigration and high immigration levels. And my particular ongoing project is to apply the environmental laws to immigration. Now, a lot of people, when I just tell them that I study the environmental impacts of immigration, just say, I don't know what you mean. Immigration isn't an environmental issue. And, that would be funny to the people who, started the immigration control movement back in the 60s and 70s. Population growth was one of the biggest things that people talked about. So when the first Earth Day was started, population growth was like the big event, and it was both national and global population growth. But environmentalists were really attuned to the fact that, like, the bigger the population, the greater the impacts people have on the environment. So whatever you're thinking about, pollution or water use or resource use or carbon emissions or whatever you want, it's going to be larger the more people are there. And specifically in this country, the larger our own national population is, the more environmental impacts we're going to have to deal with. So one of our emerging problems, for instance, is urban sprawl, which is generally caused by developments, around cities. The cities are growing out, and Americans' open spaces are vanishing. So the question is, why is this happening? It's because of population growth, like specifically American population growth. And in America today, immigration is the reason we're having population growth. So back when the environmentalists used to talk about this more, it was more a matter of birth rates. So immigration was low until the 1970s. And then in 1965, with the Hart-Celler Act, we kind of opened up immigration again. And simultaneously, our own birth rates, stopped being the cause of growth, so the baby boom ended. So we had this shift between population growth having nothing to do with immigration and population growth being caused primarily by immigration. And now when the Census Bureau projects population growth in the future, they think like 98% of it in the coming decades will be caused by immigration, like if nothing changes. I mean, things often do change, but those are projections if we keep our current course. So the reason I'm involved in that is because in 1969, we passed a law called NEPA, or the National Environmental Policy Act. And that's been called the Magna Carta of our nation's immigration laws because it was kind of the basis for the rest of them. It was the first, and it basically said that all actions that agencies take should be taken with a public involvement and with accountability if those actions are going to have an effect on the environment. And NEPA itself specifically mentioned population growth as a matter that the agencies should be thinking about. So they said, here's its preamble was, Congress, recognizing the profound impact of man's activity on the interrelations of all components of the natural environment, particularly the profound influences of population growth, high-density urbanization, industrial expansion, resource exploitation, and new and expanding technological advances, et cetera. Declares that it is the continuing policy of the federal government in cooperation with the state and local governments and other concerned public and private organizations to use all practical means and measures, including financial and technical assistance, in a manner calculated to foster and promote the general welfare, to create and maintain conditions under which man and nature can exist in productive harmony and fulfill the social, economic, and other requirements of present and future generations of Americans. So basically, they were saying, let's think about our environmental issues before they happen, and they made it a requirement for all agencies to think before they act. And it ended up, but that was a very broad law that kind of left it to the courts, and they also created the Council for Environmental Quality, which is an agency within the Executive Office of the President. So they kind of left it to the CEQ and the courts to kind of figure out what that meant. And they came up with this NEPA process where, first the agency identifies that they're taking an action, and then they decide, is this going to be significant or not? So many actions they put into a category of, not something that by its type would not have a significant effect on the environment. That's called a categorical exclusion. And then if they decide it's not categorically excluded, they usually do an environmental analysis, so that's an EA. So they look at what they do what's called a process of scoping. So they have public meetings and they identify, what will the action do. So this action could be anything. It could be like, giving a permit to build something. It could be promulgating a regulation. I mean, it could be anything that has an effect on the environment. And then if after the environmental assessment, they either decide it's not going to have a significant impact, or we're going to take action to mitigate that impact, and they issue a finding of no significant impact, or they do a more elaborate analysis called an environmental impact statement, so an EIS. So there's this scheme, and people have kind of grown to think of it as something they do before they build a structure, before they build, a bridge or something like that, before they make a physical structure. But the truth is, that's not what the law says. And one of the biggest environmentally impactful actions that our federal agencies take are the actions that create population growth, because there's several specific programs that bring in people, about 1 million legally a year. And those never went through the NEPA process at all. It's sort of like it was forgotten about. It's not that the agency decided they were categorically excluded. They just never did anything at all. So I went and I looked back at the INS. So before DHS, which currently does immigration, it used to be run by the INS. And I looked at the INS's NEPA procedures, which were passed in 1981 and approved by the CEQ at the time. And it says, we'll do environmental analysis when we build a detention facility. So like the only thing we ever do that impacts the environment is when when we have immigrants in detention, which sort of begs the question, like, okay, so if they're not in detention and people come into the country from other places, they don't have any impacts, they only have impacts when they're in a government facility. I mean, it doesn't make much sense if you think it through, but they never stop to think about it. So that's kind of what I'm trying to do with the lawsuits, and also just with my papers explaining why. Because if you look at some early cases, quite a lot of the agencies didn't really want to do any NEPA. They sort of like, what we do doesn't really impact the environment. And in the last few years, DHS has made some response to comments from the public, asking them why they don't, like for instance, when they promulgate a regulation that changes immigration levels. And one thing they've said is they don't need to speculate. They don't think this applies because they don't need to speculate about it. And an early case said about that, the agency doesn't need to foresee the unforeseeable, but by the same token, it can't avoid drafting an impact statement simply because describing the environmental effects and alternatives to a particular agency action involves some degree of forecasting. And one of the functions of a NEPA statement is to describe the extent to which environmental effects are essentially unknown. And they can't just reject any attempt by labeling any discussion of future environmental effects as crystal ball inquiry. So I think it would be very possible for, DHS and USCIS specifically to have like a programmatic analysis of, what its programs do and, what the impacts are of the people that come, and to hear from the public. And one of the reasons why I think that's so necessary today is because we are living in a very divided time. And I think the American people don't feel like they have a voice on immigration, really. I mean, I think we get a lot of talking about what the perspective of enforcing the law is, but you know, the people who live here and whose lives are affected by population growth, I mean, they need a way to voice that too. And part of what NEPA is about is it's not just, you know, the natural environment specifically, but the human environment. And so it's also about giving people a role in the administrative state in a way. So, you know, it was people don't really have one. I think people are feeling less and less like they have a way to get their government's attention these days. So one of the things NEPA does, which I think it does very well sometimes and less well in some cases, is it gives you an opportunity to see what the government thinks is going to happen because of one of its actions, and you know what that impact is going to have. Like, I attended a local NEPA hearing on a sewage plant in my own town, and it was great because it was like, oh, okay, this is why my water bill is going to go up, and you know, I got to see it, I got to make a comment on it, and you know, a lot of the environmental impact statements that they do. You know, like if they say we need to build a dam. Why do we need to build a dam? Because there's going to be a huge amount of population growth in this city. Okay, so that's just taken as a given. But there's never ever an analysis of like, okay, so we're going to have this program which will increase the population. What will that mean? What kind of infrastructure will we have to build because of that? There's no reason why we couldn't have an analysis that allows for that, and it would be good. It would give us information. It would give us information about what needs are going to change because of the population growth that is inherent to an immigration policy like ours. And I think that would be a very beneficial thing in a time when our immigration debate is very heated. So, you know. But you know, it's very hard to change the status quo. I mean, they seem to have gotten away with just not doing it for a long time, and that's what I'm working on. Anyway.
Okay. Sure, I'll offer some comments. Appreciate being here to talk about this interesting subject, but I want to do really briefly say a little bit about kind of the administrative law aspects of thinking about the environmental impacts of immigration, and then say a little bit about whether or not population growth and numbers domestically, or how we should think about population growth and domestic population for environmental policy more broadly. On the first point, it's certainly true that the purpose of NEPA is to require a holistic evaluation of major federal actions that could have a significant environmental impact, and that in principle it should not matter what sort of policy is under consideration, that sort of requirement should be upheld, and that it should apply across the board to all governmental actions. When we look at immigration, there are two things that sometimes get in the way. With that. One is Congress has created exemptions for certain sorts of activities with regard to NEPA evaluations. So national security related actions often do not have to comply with NEPA, or if they do, they have to comply with the way in NEPA that makes it for all practical purposes that NEPA was not complied with. So, for example, requiring the military to conduct an environmental impact statement that will never be revealed or made public doesn't really fulfill the purposes of NEPA as they relate to informing the public or facilitating debate and evaluation. But Congress has also, for example, at times created authority for, within immigration agencies to waive environmental review. And so, for example, I always forget the name of the statute, so I'm going to pull it out. Section 102 of the Illegal Immigration Reform and Immigrant Responsibility Act of 1996 creates a mechanism whereby agency officials can waive the requirements for environmental review, and that has been done about a half a dozen times over the past 15 years, most recently for the purpose of expediting border wall construction along the southern border in California. So the fact that we have these exemptions are one reason why we don't always get evaluation of environmental impacts in the immigration context. Another is that a lot of immigration policy decisions occur in the context or the types of actions that are not clearly subject to NEPA review. So for example, changes in guidelines for how deferred action applications should be processed or reviewed is not clearly the sort of final agency action that would be subject to NEPA review. And in fact, that's something that is possibly going to be addressed this term in the Supreme Court when they evaluate the legal challenge to the rescission of DACA. If DACA and DAPA and similar policies were exercises of enforcement discretion, it's not clear that they are subject to judicial review at all, nor is it clear that they are the sort of agency action for which NEPA review would be required. That said, if we do environmental review of immigration policies, it's important to know this cuts in a variety of different ways. Or groups like the Sierra Club have filed suit challenging border wall construction because they're concerned about the effects of border wall construction on habitat. A lot of species don't respect national borders. They don't read maps. And what may be a relevant border for purposes of foreign policy or our relations with our neighbors may not be relevant from a habitat standpoint. It's also true that we know that one consequence of things like erecting border barriers, modifying where people can and cannot cross the border itself has environmental impacts insofar as we are diverting population flows to different places, and that can have environmental impacts. So policies that restrict immigration policy certainly can have negative environmental impacts as well.
Can I respond?
I was just going to make one other point and then hand it back over to you. More broadly, in terms of immigration and environmental policy, it's worth thinking about that the post-1965 increase in immigration coincides with what has been a pretty miraculous set of environmental improvements in this country over the last 50 years. Improvements in air quality, water quality, increases in wilderness protection. Over the 20th century, we saw a dramatic increase in forest cover in the United States. So at least in countries like the United States, it's not clear that if we're concerned about the levers that most affect environmental outcomes, that population is really the lever that should be our greatest concern. While certainly holding all else equal, increasing population increases environmental impacts, we have shown that increasing population is compatible with degrees of environmental improvement, and that changes in affluence, changes in technology are certainly more significant levers if we are concerned about environmental progress on the ground, and that if our primary focus is environmental policy, we might want to think about that. Replacing copper wire with fiber optics and then replacing fiber optics with wireless is far more important in terms of our environmental impact than the sheer number of people on the world as a whole or the number of people in a given part of the world like the United States. And then finally, I would just note within the economic literature, there is a lot of research that suggests that increases in population density do in fact contribute to economic growth and technological innovation. Those of you that work in innovation spaces knows that it's good to have more interactions and more networks with more people thinking about problems. That's one of the ways we facilitate innovation. And if one believes that issues like climate change require focus on innovation, then policies that alter the underlying economic context in which innovation can be encouraged are effects that we should think about as well. So those are some thoughts I would add to the question about the intersections of immigration, population, and the environment.
Okay, well, in response to your first question that there's exemptions for certain policies, there definitely are. So my claim, though, is that it's not about immigration enforcement mechanisms, but about immigration policies themselves, specifically legal immigration programs, which are generally started at a specific point. Like, for instance, our family immigration program is created at by a specific regulation at a specific point in time. So, so is our employment visa program, is our U visa program. So what I'm saying is at the point that a regulation creates a new way into the country, there should be some sort of NEPA analysis. It should at least be factored in. So like when an agency has NEPA procedures, so they currently have NEPA procedures that don't talk about immigration at all, but that's in fact a huge part of their mission. So there's no exemption for immigration related for immigration related matters in the law. There could be, Congress could write one, but since there isn't now, they should incorporate it into their framework, and then when they pass, when they create regulations or when they make choices, you mentioned DACA, maybe not, depending on what it is and where it fits in their framework, they would know what to do and how to analyze it. The problem with them is that they don't really deal with it at all. They don't have it. They don't have a framework to deal with it. So I don't think you can say it's exempt because immigration could be a matter of national security. I suppose enforcement of immigration could be. I'm not sure if you could say it would be a national security problem to stop immigration, therefore, the continuance of all these programs is a security issue, and so it's, it can't be analyzed under NEPA. Then anything could. There's no reason to say that, I think. And I think the other question about whether we have ways to deal with population based on technology, sure, the better your technology is, the more population you can sustain, but that doesn't mean that you shouldn't do the analysis, and that doesn't mean that you won't have effects, because population technology change isn't instantaneous, and not all things will miraculously disappear with technology. There is a certain amount of space that people take up, and the way people want to live, people may want to live in a more unregulated way. They might want to live with more open space. They may want to have larger houses. You can always adjust your behavior to make less of a ecological impact, but it's part of the analysis is figuring out, what adjustments will we have to make, what technologies will we have to adopt if we want to maintain our current impacts, if we have increased population. So I think having the analysis is not a problem. Just because you have the analysis doesn't mean you decide which way is right. It just means you have the analysis.
No, I agree with that. The one clarification to make on DACA and DAPA is it's not that they're national security issues. It's that actions that are in effect changes in enforcement policy are the sorts of actions that are generally not considered to be subject to NEPA, and it's not clear that they're subject to judicial review at all. Under the Administrative Procedure Act, we typically only allow judicial review of final agency actions. So certainly a new regulation that dramatically changes standards for entry into the country or the ability to obtain a green card or whatever else would potentially trigger NEPA, and if it was determined that such a change in policy would have a significant impact, then an environmental impact statement would have to be provided. But a lot of the things that occupy our so, for example, the changes to the public charge rule that the Trump administration recently finalized and that are currently the subject of litigation, it would certainly be appropriate, and the agency would normally be obligated to make the initial determination under NEPA of that regulatory change. But a lot of the other issues in immigration policy that we tend to focus on, like DACA and DAPA, just as a category, aren't the sorts of agency actions that we typically subject to the sort of analysis that NEPA requires. It doesn't mean they don't have environmental effects. It means that NEPA has been interpreted in such a way that we just don't apply it in that context. And so, immigration policy often occurs in a context in which these sorts of reviews are not going to occur unless either CEQ changes the regulations implementing NEPA or Congress revises NEPA as well. And you know, it's not the only policy area where we see that, but it's certainly an area where we do see that.
Julia, I wonder if you might speak a little more to Jonathan's point, in particular about population density not necessarily being inimical to economic progress, but rather a factor or reason for economic vitality.
Is population growth the reason for economic? I mean, I do think, I'm not an economist, but I do think at a certain level, your economy grows the larger your population is. I don't think necessarily that your quality of life grows the larger your population grows. I mean, I think, you could find a country with a really large population that has a larger economy than a smaller, richer country, with a higher GDP per capita. So I mean, I would say at some level, yeah, if you add to the population, someone's going to be making money. There'll be more consumers buying things, but I don't know that like your quality of life will necessarily increase. So that's not. I don't think that's necessarily true.
I think at this moment, a little bit earlier than we had planned, but we can open it up to some questions from the audience. If folks do have some questions for our speaker or Professor Adler as well. Yes, in the back. We have a microphone. Hold on one moment. Is there a microphone? Do we have a mic? Shout really loudly.
Thank you. Thank you for coming. My question is to you. You mentioned briefly about the American people do not feel like they really have a voice in immigration now. So basically, I just want to know what angle you come from, subjectively or objectively, because I think the American people always do have a voice because this is their country. It will always be Americans' country. So I do not understand that perspective you come from. Also, just a second to that, you mentioned recently about this statement about specifying a country that do not have a larger population but do have a greater GDP or something like that. While I believe there is, I might not have it off the top of my head now, but I don't think there's a great connection, in trying to just touch on the environmental and the. Oh, thank you. I don't think that's a great connection just to try to develop that thesis that you say economic growth, because I believe immigration, increase in immigration also flows from increase in economic growth. So I just want to get your own perspective fully from that.
Well, I mean, for one thing, I would say that, there hasn't been like an immigration law passed in a while. I think since the mid-90s, a major bill. I mean, I think a lot of the problem is the political class wants to pass a certain kind of bill, and they tend to be unpopular when it comes to the floor, and the people make their yes. I mean, they always get to call Congress when something is on the floor, and talk about how they say this is what I think of this bill. And a lot of times what ends up happening, or what's ended up happening in the past 15 years or so, is nothing gets passed at all, which I think suggests that they're not very happy with what the politicians want to pass. So, but there isn't a place in the administrative state where many decisions are made today, because if Congress isn't acting, the action is in the agency, the executive agencies. So if the action is in the executive agencies, when do Americans get to weigh in? So I guess what I'm saying is NEPA would be a good place for them to be able to do that. Yes?
Yeah, my question is how often is analysis under NEPA being used for other beyond the scope of immigration?
Oh, I mean, I don't know exactly how many, but all the time. The Department of Energy actually has a website where you can look at like uh, a lot of them, in all kinds of contexts. So if you're interested, I can show you the link. But
I mean, they're required across the board. I mean, all agencies theoretically are required to do them. It's certainly true that historically, agencies that had not always conducted environmental assessments were not eager to have to do environmental assessments in the context of whatever it was they were doing. And a lot of the early litigation involved the Department of Energy, which generally saw its mission as promoting energy development, and so didn't like that it suddenly had to start doing these significant studies. And environmental impact statements, if you have to do one, can be quite large. I mean, they can be thousands of pages at times. And there certainly is a fair amount of wrangling by agencies today. There are agencies that certainly try and get around having to do them. So because what triggers the environmental impact statement is an agency action that will have a significant environmental impact, agencies are aware that if instead of doing one big action, you do a bunch of small actions, then maybe each small action doesn't have a significant impact, so you don't have to do an environmental impact statement. And there is a fair amount of litigation policing when agencies can legitimately do that and when they can't. These days, most of the environmental impact statements, though, are certainly done by Department of Energy, the Forest Service, Bureau of Land Management, agencies that are heavily involved in resource development or resource use. The Environmental Protection Agency, though, generally doesn't do environmental impact statements. Portions of the Clean Air Act and Clean Water Act exempt the EPA from EISs for some other activities, and then under current law, the EPA maintains that as long as it does an analysis that is the functional equivalent of an environmental impact statement, it doesn't actually have to do one, and that's something that courts have generally upheld with regard to the EPA, at least.
And courts, agencies can be a little. They can sometimes say, "Oh, this action is categorically excluded," when it's not. Like my co-counsel told me that if you remember the Gulf oil spill 10 years ago now, apparently there was a categorical exclusion to get their permit, and as we can see, that really was an action that had a significant effect on the environment. So, but it's very hard to challenge a categorical exclusion because it goes into a black box, or like, well, it's categorically excluded, so that means we don't have to analyze it. Well, how do you know? But we know because it's categorically excluded. So there's a sort of a tautology there, or there can be.
I can just follow on that. Have you, Julie, detected, is there any difference depending on the administration in terms of compliance with the NEPA mandate?
Well, I would say, yeah, sometimes. For instance, the oils. If something is very unpopular with an administration, it might do a more full-blown, slow it down analysis. But it might not. Sometimes, you can never guess. Sometimes, in court, a lot of times there's no difference at all. Like in court, they fight the exact same way wherever you are, whether it's like something you'd think would be popular or something you think wouldn't be. Like my co-counsel in my case is like, yeah, in environmentalism, they all just want to win, and that. So maybe sometimes, but not something I've seen.
I was going to add on that. There are areas where a NEPA application where you've seen dramatic changes from administrations. So, for example, the evaluation of climate change impacts under NEPA, the Obama administration had adopted rules for that the Trump administration is in the process of trying to modify. And certainly, one area where immigration could have an significant environmental impact is with regard to greenhouse gas emissions. Right? Per capita emissions in the United States are higher than in a lot of the countries where immigrants would be coming from. So if you assume that nothing else changes about that individual, they will produce more greenhouse gas emissions here than in their home country. Perhaps offsetting that in part is that emissions per unit of GDP are lower here than in a lot of the countries where immigrants may be coming from because of greater economic productivity here. But certainly that is an effect, and there's a dramatic difference in the way that the Trump administration wants climate change impacts to be evaluated under NEPA, as well as a change in the way that extraterritorial impacts are evaluated. So particularly in the context of large energy projects like the Keystone Pipeline, things like that, there is a debate about the extent to which NEPA review should be solely focused on effects that are felt within the United States or should include effects over in other countries. So if a pipeline in the United States means there's more gas production in Canada, should the NEPA review include the evaluation in Canada? And in the immigration context, that might include, well, if we are making it easier or harder for people to come from other parts of the world, should we not only look at the environmental effects here, but should we also look at the environmental effects in the countries where they're coming from? And that the Trump administration has generally been more skeptical of the value of such assessments, but also analytically how accurate. There's a lot of question about how accurate assessments are and whether we have the knowledge base to make those sorts of assessments when we're talking about things that are extraterritorial. And that's an area where we've seen administration differences too.
I mean, there's also a potential to re-promulgate the CEQ regulations under NEPA. I mean, about a year and some ago, the Trump administration asked for comments and said they were thinking about doing that. They haven't changed the regulations since 1978, which I think was the first time they did it, or the first time they established them. And, I mean, I think that could be a very good idea. I mean, I also think incorporating immigration would be a great idea if they did it. But also not just that. I mean, I think there's been a lot of technological change since 1978, and there's ways we could make analysis and more cheaply, but more effective if we incorporated the things we have into the regulation, the technological changes with the internet and things like that into the regulations. But there's been it got a lot of people upset when the proposal was made, because they're like, oh, don't take away NEPA. And at this point, I don't know that that's going to happen unless, it depends on what happens in the election next year, probably. But we'll see. But it's definitely like this is a time that we could see some major changes in the next few years, and it's not a bad time since there hasn't been any change to the regulations since 1978. The CEQ regulations, I mean.
Yes. What do you think about Trump's policy about merit-based immigration?
I mean, that's kind of beyond my pay grade. I'm a litigator for the CIS, so I wouldn't really want to step into the policy arena, from my personal opinion.
On the litigation piece, I wonder if you might give us an update on where your litigation on these issues stands.
Well, so we did, the DOJ decided to kind of chop up our case with a motion to dismiss 2 counts, which had actually won, which we will appeal. We had 5 counts total. And the judge ruled for them that the NEPA procedures were not a final agency action, which I thought was really not well put. We will be appealing that, but we have to wait until the summary judgment motion on the final 3 counts is finished to get there. I thought they actually in their second motion they kind of alluded to their final NEPA regulations, which I thought, oh well, you just called them these tentative things that aren't even final. So we'll see what happens. So that's where it's it's the first case, but we'll see what happens to it.
I would like to ask Julie, what do you think about waiving NEPA for the building of the wall the border wall for Southern California. Do you have any thoughts on that?
I mean, again, like that's what the law is. So I'm going to stick to, I don't want to talk about like whether I think that's a bad or good policy decision, since I'm not a spokesperson for policy. Well, I mean, so there's a lot, like if I sued on it, I wouldn't get anywhere because it's written into the law clearly. But is that an appropriate or inappropriate exemption is another question. The reason why I'm suing over immigration is there's no exemption written in, so it's a different scenario. I mean, a lot of people link the two cases, but like they're really not. They're not that linked. Like if there were no exemption, there's no question it would apply to the wall. You know, if there weren't an exemption, it's clearly a infrastructure that without an exemption would have analysis.
Well, I wonder if we can get you maybe wearing your litigation hat, though, then, since the DACA case, which Jonathan has alluded to, is only 4 weeks away to be argued in the Supreme Court. Whether you might share any thoughts on that. I don't know if CIS has filed a brief in that case, an amicus brief of any sort.
We haven't filed one in that case. We don't believe it's a we do believe it's illegal. I also do believe that it was that Judge Haynen's original decision saying it should have been if it was going to happen, it should have been done through the APA was correct as well.
Actually, I apologize for folks. Maybe if you want to just give a brief description of DACA, and then I get to DACA.
Right. Well, so DACA and DAPA are basically, I mean, it's been a while since I've looked at this, so because I haven't been working on this case recently. Is basically the administration, deferred action on children who came here as minors, and he wrote in, he had like standards. You had to come here at a certain, I think it was between 2007 and 2015, or 2007 and 2012 or something like that. At a certain age, and you had to be a certain age, and you had to be in school of some kind, and not have a criminal record of some kind. So there was a program, and he said this is just the Obama administration said this is just prosecutorial discretion. So all we're doing is saying, you're at the end of the line, and we're not going to be enforcing the law on you, and we're giving you, a certificate to that end, and it's not anything other than us using our discretion not to prosecute you. But some judges have said no, it was more than that. It was actually a program, because not only did you say, we're not going to be deporting you, you also got work permits and basically got legalized status, and you kind of had this quasi-legal status that was treated as legal by many states and in many ways, and it led to driver's licenses and things like that. So the original Judge Haynen in Texas, who originally looked at DAPA, which was the second program, which was for the parents of the minors who had DACA, he had stopped it, and he said, it's not legal. It probably wouldn't be legal. I mean, he kind of hinted that it wouldn't be legal, but he also said if you do a program like this, you would have to put it through the Administrative Procedures Act with notice and comment, because it's not just an exercise of discretion. So I would say that at least is true, and I would say that he should have put it through NEPA too. But if it's not going to be remaining, it's probably not worth making a big point on the NEPA. We'll see whether it survives.
But then, just to be clear, the Trump administration
Oh, yes. So the Trump administration took it back, and then several judges said, no, you can't take it back, which I thought was really unsupportable, because if you had to, if you could if you could do it without the Administrative Procedures Act in the first place, it seems pretty crazy to say you'd have to put it through the Administrative Procedures Act to take it back. I mean, if it's discretion or it's not discretion, like in my view. And if it's purely discretion, then he can take it away. The Trump can take away whatever Obama gave. And if it wasn't purely discretion, if it was more than that, Obama didn't have the right to give it in the first place. I mean, that's kind of where I come down. But again, I haven't looked at this recently, so like, you know, don't see me as the big authoritative source on this.
Appreciate your insight on that. I don't know, Jonathan, if you have anything to add on DACA.
I mean, I agree that the Trump administration's position is probably the legally correct one, in that if DACA was an exercise of enforcement discretion, then it can be rescinded without any process, and that the sparse justification that was given is more than sufficient for a change in enforcement discretion. I'm inclined to believe that the Obama administration policy as an initial matter was legal, because deferred action itself was merely an exercise of enforcement discretion, did not confer an actual change in status or any actual rights. And the policy of allowing work authorization for those who are unlawfully present but for whom are not going to be deported is something that goes back decades. In fact, one of the early beneficiaries of this policy or of this practice was John Lennon, who was going to be deported for, I believe it was unlawful drug possession. And when deferred action was given to him, he was also given a work permit so he could continue to record albums in New York City. This practice by the executive branch has been conducted continuously and openly with the knowledge, acquiescence, and indeed encouragement of Congress for decades. And so if one were to apply, Justice Frankfurter's formulation in Youngstown Steel for my students that are in the room, the practice of giving work authorization to people who are unlawfully present but who are not going to be deported would seem to be a textbook example of that. So I think what Obama did, whether it should have been done administratively or not, I think it was legal, and because it was legal, the Trump administration does have the authority to rescind it, I expect that's what the Supreme Court will do. The real question will be whether it's 5-4, 6-3, or 7-2.
I mean, it was never, just because there were some grants of deferred action in the past, it was never given on that scale, and it was also never given. I mean, generally when it was given out before, it was to people who had some sort of expectation under the law of eventually getting status, and it was more of a bridge status. I mean, the way the Obama administration did it, when he took like really large groups of people who had no actual path in law, like there hadn't been a law, there wasn't like an amnesty that already had been passed for them, they just hadn't gotten it yet, or there was no reason for them to expect under current law that they would later become legal. There was nothing like that for them, and then under that scale. So I would say that past grants don't provide any kind of precedent for the kind of program, 6 million person program that the Obama administration created. And, I also don't think that, if Congress ignores a few things, that it means that, it really meant to give away all its power. I mean, I also think, if granting, if letting the DHS secretary give somebody a work permit means like our whole entire structure of when people get a work permit and when people don't, our very elaborate structure of giving out work permits under our immigration laws is pretty much nullified if you can just give them out whenever you want. So I would disagree with that, and disagree that precedent has established it.
Just want to add just a little bit of context for those who may not be aware. Obviously, 3 lower courts, the cases are consolidated, of course, found to the contrary, that they view the rationale of the Trump administration to be arbitrary and capricious. And though the claims aren't before the court, the plaintiffs have brought claims that the reasons for the rescission violate the Equal Protection Clause and violate due process as well.
Those aren't going anywhere.
So Professor Adler does not think those are meritorious, but
If you can't win on those claims with regard to the immigration executive order, you're not going to win those claims with DACA. I mean, that just from a very pragmatic standpoint.
immigration executive order being the travel ban.
Travel ban, right. That those sorts of constitutional claims weren't going to be successful in that litigation. They're not going to be successful here, where the record and basis for those sorts of claims is a much more difficult one. So, I mean, I just don't think that's really on the I don't think that's really on the table in terms of what the Supreme Court's going to.
Right. No, and the court is not addressing those issues. We are pretty much done with our time. We will adjourn to the rotunda area for reception. Thank you. Please give the word again.